Hello, and welcome to SLW Institute's International IP webinar series. My name is Greg Stark, and I am a principal with Schwegman, Lundberg, and Worcester. Today's webinar, You Got the Look, Design Protection in Europe, will be presented by UK patent attorney John Gray. John Gray is a seasoned intellectual property attorney adept at advising clients and obtaining protections for innovations across a wide range of technologies. John is a 5-time Managing Intellectual Property IP Star Award winner and is of counsel with Schwegman, Lundberg, and Worcester. John joins us today from the UK. To submit a question, please feel free to use the Q&A feature on the webinar menu. John will address the questions either during the presentation or at the end of the prepared presentation. Thank you for joining us. Now John will enlighten us on obtaining design protections in Europe. John, it is all yours.
Well, thanks very much, Greg, and hello, everybody. Thank you for joining. Design protection in Europe is the subject, and I'll just give you an overview of what we're going to discuss. Particularly, the focus is registered designs in Europe, which are also called Registered Community Designs, or RCD, and this is the registered designs is the equivalent in European countries of the design patent in US law. I hope it's okay if I assume that the listeners are mostly familiar with the concepts of patents and trademarks and designs as concepts. I'm going to talk about the basic features of EU registered designs and the requirements for novelty and individual character. I'm going to talk about what features are excluded from protection, how you determine the scope of protection for infringement purposes. I will compare as far as I can with US practice, which I'm certainly not an expert in. There are some things you can do in Europe that you can't do in the US, but there are some dangers as well. And we'll focus particularly on the need to think about visual disclaimers. It would be very topical of me this week to deal with the subject of Brexit because the UK is about to leave the EU tomorrow evening, but there are transitional arrangements I'll cover. I'll also briefly mention, possibly as an opportunity, but also as a hazard, some various unregistered design rights that exist in Europe and the UK. So if that's all right with you, I'll proceed and start talking in more detail about European registered designs. So registered designs covering the whole of the EU, which is 28 countries, 510 million people today, are filed and granted by the European Union Intellectual Property Office. They're called registered community designs for historic reasons because we used to be the European Community and then we became the European Union. It's very important and of course very confusing when you've got the European Patent Office as well, and the EU IPO is not the EPO, as I've mentioned there, and it's the European Patent Office is an organization independent of the EU. So the good news on that is that European patent matters are not affected at all really by Brexit. So we're talking about the EU Intellectual Property Office and the law, which I'll give some article numbers just in the slides. The law for this is the Council regulation of that date. So one feature of EU design registrations is that they are very quick to issue, to grant if you want. It can be a few days if everything is in order. There's no examination for prior art, only for clarity and formal requirements. But the filer can request deferred publication up to 30 months from the priority date. We'll see what a wide range of designs can be protected. You can also file multiple design applications. So an application with tens, dozens of designs in it, which can be very cost effective. The enforcement of these rights is through national courts, but of course a registered right like this can be very handy for takedown procedures on online marketplaces like Amazon and so on. Invalidation actions, if you want to challenge somebody else's design registration, those happen through the EU IPO, so centrally there, and through appeals through EU courts. The duration of a European registered design is up to 25 years from the filing date, but with a renewal fee due every 5 years. The EU is also a member of the Hague system for international design registrations. So most of what I say here goes for the EU designation of a Hague registration. Looking at novelty, we find some quite strange language in the design regulation, which every few years a court case comes along which clarifies what this has meant. There's obviously not as much design litigation as there is patent litigation, so a lot of questions about what these terms mean can wait for a lot of years before somebody says, aha. So, but novelty, the design must be new, meaning no identical design has been made available to the public before the filing date or the priority date. And designs are deemed to be identical if they differ only in immaterial details. If that ever became critical, you would just have to write about what that is. There are some exceptions to the prior art. A very obscure disclosure somewhere in the world will not necessarily be prior art or prior disclosure. And the wording for that is highlighted there. Whether things could reasonably have become known in the normal course of business to the circles specialized in the sector concerned. There's a lot to unpack there, but it's been considered in some cases which we can mention. But the aim is so that some obscure event doesn't anticipate your design. Very different from European patents and more familiar to US practitioners, European designs have a grace period to protect against disclosures by the owner themselves, which extends 12 years behind the filing, 12 months behind the filing or priority date. So that's a feature that can be very useful if you want to try out your marketing, or if you have tried out your marketing in the same way as a US grace period. On top of novelty, the design has to have individual character, which I suppose, thinking from a patent background, is more like inventive step or non-obviousness. And here we get some more interesting phrases. The design shall have individual character if the overall impression it produces on the informed user differs from the overall impression produced by the prior art design. So we get these two key phrases here, overall impression and informed user. And then it also says that for assessing individual character, the degree of freedom of the designer in developing the design shall be taken into consideration. And what that really means in practice, we can talk about again with examples later. But if technical requirements mean that the thing has to be roughly like that, then differences within that narrow band become significant, and the scope of the designs is generally seen to be narrower. So who is this informed user? Well, there's a very important case, Grupo Promer versus PepsiCo, which concerned promotional discs called Tazos or POGs, which are used as collectible items for children. And the informed user is not the average consumer, but it's also not the specialist designer of these products. It's an especially attentive user and a knowledgeable person in the sector. And in this case, for promotional items, there were judged to be two informed users. One group who are marketing professionals who might want to use promotional collectible items like this, and the other group of informed users were actually 5 to 10-year-old children. So the informed user is judged on the circumstances of that case. Certain features are excluded from protection, and the first one of these is features which are dictated solely by the function of the product. These designs, registered designs, are very much for aesthetic and appearance of products. There are also exceptions for features which must necessarily be exactly of certain form and dimensions, such as this USB plug on a clothes peg-shaped USB stick. And this is a feature which has to be mechanically connected to something else in order to fulfill its function, and we call that the must-fit exception. And there's also another protection, exemption, that is for the look of articles which are actually replacement parts for a more complex product. So that would be a car body panel or something like that. Doesn't have independent protection from the shape of the car. So we have the must fit and the must match exceptions, which are common in European design laws. So the scope of protection for infringement purposes as well as for individual character is expressed in terms of any design which does not produce on the informed user a different overall impression. And again, in assessing the scope of protection, the degree of freedom of the designer shall be taken into consideration. So overall impression sounds quite woolly. It can be, it's not the vague look. We'll see again some examples. It's not the vague look of the product, but the overall summation of similarities and differences, all kind of weighted in accordance to their importance, and also all weighted in relation to how different they are from the body of prior art. So it's quite a vague and moving target, and a difficult thing to get your head around, but that's how it is. Importantly, for EU registered designs, the scope of protection is communicated and defined purely by reference to the views, the images. The registration has a designation of the product, has a title. There is optionally a description you can file, and it has a class and a subclass within the Locarno classification. But all of these things are completely ignored in determining the scope of protection. So visual disclaimers, something that you can fit in the drawings, is about all you can do. But if once you've got the hang of that, and once you realize that you're going to have to do that, then there's quite a lot of power in your hands before filing to make that work. Moving on, we'll look at some examples of what can be protected. As we've said, they're all the usual, but there's some more freedom, I think, than the US in relation to graphic user interfaces and screen icons. They can be protected without necessarily being shown in context on an abstracted kind of screen. There are examples here of animated icons, such as the mail envelope folding up and flying away here, or the progress circle here shown in stages. We have a typeface here. We have the get-up of the inside of a railway carriage. We have, of course, a mobile phone. We have packaging. And particularly in view of the quick registration. It can be that a design registration in Europe is a way to get something that is effectively a trademark right for something that might be slow or difficult to register without prolonged use in trademarks. So there can be a use for designs where you get the first years of protection by a design registration, and then after time, whatever it is becomes registrable as a trademark. But you've had your registration in the meantime. In terms of adapting practically, if you're starting from a US design, a priority filing, for example, and coming to Europe, then typically the US drawings will work with minimal changes of the type I might mention later. So that's the good news. If you've already got black and white line drawings, then that's a good start. We often find that going the other way is more problematic because the European or other priority application is in photographs, color, whatever. So it should be relatively painless coming over, but then there are some difficulties or hazards. So one of those I've mentioned here, there's only 7 views permitted. The more views can be filed, but they are disregarded for defining the protection. So if you have a simple object with a top view, side view, back view, front view, bottom view, and a perspective view, that's the basis for a nice 7 views. But if you start having objects that open and close into different positions, or are complex products, or products where you want to zoom in on a detail, or have an exploded view, then it becomes a world of challenge and compromise to fit into only 7 views. And typically I would select some of the original views to become view number 8 and 9 for the information. Multiple designs can be effective, as we'll see later as well. And as I mentioned already, no amount of wording around the drawings can extend the protection or limit the prior art. And I noticed in the US, there was a case recently where the title "Pattern for a Chair" on the design patent here, the title was effective so that the use of that design on a basket did not infringe the US design patent. We would expect in Europe that that pattern would be infringed by applying it to a basket or anything else. On the other hand, conversely, if you wanted in a novel way to apply that pattern to a chair, and that pattern were already known on a basket, then you might suffer from prior art if you try to protect the pattern in the abstract. You may still be able to protect the chair. Moving on. So a couple of famous cases where the hazards of unintended restrictions on scope came to the fore were in the Dyson case back in 2011, and more recently in the Trunky case. When I mentioned registered design protection to a boss of mine 20-something years ago, he challenged me to find any case where a registered design had been found infringed in UK law. I think his point was that if it's identical, then that's fine, but as soon as the design of the infringement, the alleged infringement, is slightly different, it becomes quite a lottery. And in the intervening years, statistics show that courts have not found infringement by non-identical designs. So there's a slight worry that there's a reality that the protection is very narrow, but what I hope to show in the later slides is that you can take charge of that and broaden it, learning the hard lessons from previous owners. So in the case of the Dyson vacuum cleaner, I nearly said Dyson Hoover, but we professionals are not meant to say that. The product was the first one with this overall kind of concept of an inclined cylinder on the floor and the big wheels here. Nevertheless, all the features that are in the photographs, and of course there were seven views showing different parts of the machine, including the hose and the wand, as it's called. All of these features are taken into account to assess the overall impression, and all the similarities and differences in the accused product are taken into account. And there was found in the UK on this design no infringement. I seem to recall that in France the same facts produced a finding of infringement, but the lesson is that the concept of the product, if you put in all the details of the product, then you're not going to get protection for that vague concept, even if in hindsight you could say, hey, they've copied our concept there. The judges in that case highlighted the rugged, angular and industrial impression of the VAX design versus the smooth, curving and elegant features of the Dyson. And that was illustrative of a different overall impression. So the Dyson design was filed under old law and then examined under new law, tried under new law. The trunky design was another kind of first of its kind product, this children's ride-on suitcase that you see around airports. And the design registration was made on the basis of these CAD images, and the accused product was ones of the type that you see here. So to some people's disappointment and surprise, through the High Court, Court of Appeal and the Supreme Court, it was found that these designs, there was no protection of the overall concept of the ride-on suitcase. Features, particularly that were seen to be features of the design which were not taken in the accused product, were the overall impression of a horned animal as opposed to an animal with softer ears was not taken. The lack of surface decoration, which was seen to be part of this design, so the fact that it didn't show surface decoration when it could was taken to mean that there was a lack of surface decoration where the accused product had surface decoration. And finally, a color contrast between the wheels here and the body was seen as a feature of the design, and that feature was not taken. The wheels are hidden, and obviously there's no color contrast in the accused product. So that makes it seem very difficult to get protection that you would want, even for a very distinctive product. So what do? We put visual disclaimers to work. And I think visual disclaimers are familiar to US practitioners as well. I think in the example of a line drawing, classic, and as far as the EU IPO is concerned, the recommended form of disclaimer is to use broken lines for parts of the design that you don't want protected. So in the case of this pan, the applicant wants to protect any pan with that particular shape of handle. And I would also say the use of a line drawing is almost a kind of visual disclaimer already, because it avoids those problems of color contrast being inadvertently included. It avoids anybody deciding that a lack of surface decoration is a feature of your design. So already going to line drawings, you gain a lot of control, and then with broken lines you can indicate particularly what's to be protected. Other types of visual disclaimer can be used, though, as we show some examples here. And these examples are from EU IPO guidance, which is also common to several countries. Excuse me. So there's blurring, which shows that we're talking about a tire tread, but isolates that repeating pattern of the tire. There's color or transparency in isolating a particular part of the car. So these manufacturers want you not to be able to sell a car with a front that looks like that, and you will infringe even if the back of your car doesn't look anything like that. So that's important control all of a sudden, protection. Another way of doing a disclaimer is to draw, provided it's very clear and unambiguous, is to draw boundaries around the part that you want protected. And we see some examples there as well. So that's taking control of what is protected. And then I mentioned multiple designs, and this is where if you really want to protect different aspects of a product independently, then you can do so quite readily and not at enormous cost by filing multiple designs within the one application. So in the format of EU of RCD numbering, there's a basic application number, and then there's a suffix which, as you can see, could go up to 9,999 if you wanted it to. The present example design is for a kind of keyboard and controller, a small handheld thing, I think, and there were 18 different designs in this application, and the first 3 of them were for this controller. The multiple designs in a single application don't have to be all for the same thing. They just have to be in the same ownership and have the same general class in the Locarno classification, not the same subclass, but be in the same class. So you get a great saving in official fees by piling as many as you've got into the same application. So what's been done here, looking into the mind of the applicant, they've said, well, we don't want people, if we look at design number 1, we don't want people being able to copy this general shape of fascia for a controller. And they achieve that by putting that general shape of the fascia into solid lines, and everything else is in broken lines. They have decided they would like additionally to protect that fascia shape in combination with something of the 3D elements. And I'd say again, these are just the front views out of 7 or up to 7 views showing the same thing from different angles. But again, it's completely agnostic about what the layout of shape of the keys should be. So you could infringe that design number 2 with a completely different keyboard layout on there. And then design number 3 flips the other way. You could infringe design number 3 with any kind of body for the keyboard if you come too close to that layout of the oval-shaped QWERTY keys and the bars below. So what this set of designs are saying is, don't do anything like that, and don't do anything like that. And you can understand that if one had filed just one design with all these features in solid lines, then somebody would escape infringement if they changed the arrangement of keys but kept the same body shape. And they would avoid infringement if they kept the same arrangement of keys but changed the body shape. Hoping I said that the right way around. just while we're looking at these drawings, there's some features that you can see that are a little bit different in US practice. These probably wouldn't cause a problem, but these shadings showing surface and curvature, provided they're unambiguous, I wouldn't worry about including them in a European design filing, but they're not recommended, and they could, and if they could be mistaken for features of the design, then we would recommend taking them out before filing, and that can usually easily be done either at our side or at the applicant's side. So it's important that the European attorney can have a look and advise before it becomes urgent to file. So moving on, of course, as Greg said, I'm happy to take questions which you can type in, and I'll answer them either as I go along or at the end. So some examples where visual disclaimers can go wrong, or one wonders why they were done the way they were. This is a popular brand of lip balm with a dome-shaped piece of lip balm, at least when it's new, and in a nice circular spherical case. The registered, so this is a case that was tried in the Netherlands. The registered design views had, as you can see, the shape of the lip balm, the dome shape here, in solid lines, but in all of the views, the case was in dotted lines, and therefore disclaimed. So the only feature to distinguish this from the prior art, and the only feature to be considered for infringement purposes, was really this dome shape there. The accused product has a very similar ball-shaped housing, but a slightly different egg-shaped, or in the words of the judge, pointy shape for the lip balm itself. And additionally, some prior art in a very different shape of case, but with a dome-shaped lip balm existed. So in these circumstances, it's really impossible for this product to infringe that registered design, because the points of it, which do look quite similar to the original product, are actually disclaimed by the dotted lines, and the point which is highlighted as protected, the shape of the lip balm itself, is very constrained by the prior art and noticeably different in the accused product. So of course, we never know the history behind why things are done the way they are, but in this case, it was fought through the courts, but or it wasn't fought through the courts, sorry, it was an interim relief application, but unsurprisingly, the relief was refused. And then an odd case where national courts have considered the iPad registered design. So this is the part of the very large global litigation between Samsung and Apple and Samsung. There were dotted lines on the screen of the, indicating the screen area of the iPad, and these were held by these courts to be part of the design, not disclaimed features. So it really can be a bit of a lottery what the courts do with your language when your only language is this visual disclaimer language, and you're not allowed to say anything effective in words. The case here also is quite illustrative of the considerations of design freedom of the designer. So a designer of a tablet computer is pretty well constrained to have a flat, roughly rectangular screen, and so the features of the design which have individual character and are protected turn out to be very limited things to do with curvature here and there, and proportions of thickness to length, and so on. So the design in the end was not infringed. Again, we can see these markings on here, which are intended to indicate a shiny, glassy surface. I think nobody would mistake those for features actually intended to be part of the design, so they don't do any harm. But in other cases, we might recommend taking away that kind of shading and hatching that is common in US design patent drawings. The flip side of having a very narrow scope, so there was no infringement, was that the invalidity action also failed. The design was held to have individual character, albeit in a very narrow scope. So that was the iPad story. Rushing along, we come to Brexit tomorrow evening. When I was writing this slide yesterday, the day before, the European Parliament had not ratified the transitional arrangements for Britain leaving the EU, so I was hoping I did not have to redo this slide today, but last night, as expected, the withdrawal agreement was approved by the European Parliament, and it will come into force tomorrow evening. What was 28 countries in the EU becomes 27 countries in the EU plus the United Kingdom outside the EU. And ultimately, that means the United Kingdom will be outside the registered community design system. But the transition period under the withdrawal agreement means that there will be no change in practice until the end of this year, 31st December 2020. And so there's no change in filing practices and rights until at least then. And of course, further agreements could, in theory, make other things happen. But what we do know is at the end of the transition period, looking at the drawing here, if you have some registered designs which are already published and registered in the EU form, so that's design EM blah 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 number 4 and so on, then at 11 p.m. on the 31st of December, these rights will be cloned or automatically re-registered into United Kingdom or GB registered designs with exactly the same ownership, priority details, application dates, and so on, and the same period to run to their renewal date. So you will, if you own one of these and it's in force at the 31st of December, then you'll own something else the next day automatically. And the translation into the UK register will be done by using the same application number, dropping the hyphen and sticking a 9 in front of it. So that will happen. Of course, that will happen automatically with no formal steps or fees as far as the government is concerned. And Schwegman and other firms will look at making arrangements to replicate records and so on, so that we will need to, as applicants and attorneys, we will need to make sure we create new case records for these British rights. And thereafter, as you could do today if you wanted to, you can file a new registered design at EU IPO to cover those 27 countries, and you can file in parallel, if you want protection in the UK, you must file in parallel a new UK registered design application. The laws are highly harmonized, so there's very little difference between what I said above about UK designs and about EU designs and what will apply to your UK registered design. Obviously, enforcement and invalidity will be determined solely in the UK for those rights. Minor things, you can have more than 7 views in a UK registration. On the other hand, you can't defer the publication for 30 months, only for 12 months, which is similar, I think, to international designs. Again, the EU and the UK are both members of the Hague Agreement, the Hague system, and similar transitional arrangements will be in place for designations in international registrations in time for the end of the transitional period. If you have any pending European design rights, which could be ones where you've deferred publication, or it could be ones that have lapsed due to non-payment of a renewal fee and you still want them back, then you will have to take action in the UK positively to do that, but there will be a 9-month grace period for doing all those things after the end of the transition period. That's registered designs. I said I would highlight just briefly features of what we have as unregistered design rights in Europe and the UK, just to complicate matters, but perhaps something to be aware of, especially if you were thinking of copying somebody's design. There is the European unregistered design right, and being an unregistered right, like copyright, it only protects against people copying your design. It doesn't have the same force as a registered right, where somebody could be infringing it even if they independently came up with the same design. The European unregistered design right has the same scope as the registered design, so it's for aesthetic, non-functional features. It has the same requirement of novelty and individual character when you come to try and enforce it. The duration of it is very short, just 3 years from the first publication, marketing of the design. So it's a very short-term protection against copying in the first use of a new product. But the qualification for it is limited, and this may make it of limited use to US applicants unless you plan particularly to exploit it, because the first publication has to be in the community as far as we know. There have been 2 court cases on this, and the UK court has timidly referred to the Court of Justice of the European Union for confirmation. But what happens is, if the first publication, if the first substantial publication was somewhere outside the community, so for example at a big toy fair in Hong Kong, then that means that the design has been made available to the public, as we mentioned, for destroying novelty of registered designs, but then it doesn't exist until its first publication in the community, by which time it's not novel anymore. So the logic is that you only get the protection if the first publication is in the community or publication is simultaneous worldwide. So that's how we think it works. As I mentioned, case law in this area is very rare. Similarly, at the end of the Brexit transition period, the law will be adapted so that if you have unregistered design rights, these will also be cloned into an effectively similar law in the UK. So the European unregistered design right is protection against copying, which has the same scope as the registered designs and lasts for only 3 years. And finally, there's another unregistered right in the UK, just called design right in our law, which also again protects against copying, but it is not limited to the aesthetic designs and the outside of things. This is similar to an unfair competition law that some countries have, and it's applicable to the shape and configuration of products, and it does protect functional designs in the details. It protects internal and external features of machines, There are exceptions for must fit and must match features, so you can't use it to monopolize something which has to plug into something else or fit against something else. But it has a longer term. It has a term of 15 years from the first recording of the design, or 10 years from the first marketing. On the other hand, during the last 5 years of that term, people can apply and obtain a license from as of right. Again, there's a slight territorial edge to who is entitled to these, or how you get them. And you would have to look at qualification by the nationality or residence of the designer or the owner, or qualification by the place of first marketing. So if you're worried about infringing third-party rights in Europe and the UK, you'll have to worry about particularly things that have been happening here that might not appear on registers, but could bite a US applicant, a US producer launching a product that turns out to be a copy of a product developed over here. If you're a US designer and you want to obtain the benefit of this kind of protection for your own products in Europe or in the UK, then you'll have to attend to these requirements of qualification by first marketing or first publication, and get advice on that, because you don't automatically get it if you've put the thing on. If you're an American company that has first put the thing on sale in America, you may not have that protection when you come over here. So those are two lesser known areas of design law in the UK and in Europe. And that really concludes the programmed part of my presentation. I'm not seeing any questions at the moment, but if you have any questions, please feel free to type them in.
John, it looks like we have one question in the chat. The question, it reads, can a design registration protect a unique mechanical interface, or will that fall into the must fit exception?
So it may do. What I'm just going back to the slide here. If you are the person creating something that is a modular system, be it furniture or toy blocks or something like that, if you're designing both of the things at the same time, you may be able to protect that. So we'd have to look at that. But yes, so if you're the originator of a modular system, then there may be protection, where if you're designing something later to plug into something else, there would not be protection. You'll see that there are detailed conditions all around that, which I'd be happy to look at an example and advise on.
So John, just as a follow-up on that, I believe in the US anyway, I'm not super familiar with design practice here, but somewhat. I believe in that scenario, you might, if you were going for design protection on something along that lines, it might damage the ability to get utility protection, or vice versa. If you went, and filed a utility, it may prevent you from getting design. Is that true in Europe as well?
Oh well, yes. If so a utility patent, or just a patent as we would call it, would protect how something works. If you could tell from the views in the design registration how the thing works, then that would be prior art against your patent application, unless you've filed that first. So you can imagine scenarios where somebody is using the grace period and the quick publication of a design registration in Europe to get quick protection for that, but completely blowing their chances of patent protection, utility patent protection. There is the usual kind of principles of the Paris Convention apply, which I always have to check myself. You can go one way claiming priority, but not the other. So I think you could file a design claiming priority from what you've disclosed in a patent, in a utility patent, but you can't claim, if you realize you've done this, you can't claim priority in a utility patent from what you filed in a design. Somebody can tell me if I'm wrong on that, but yeah, so there's definitely a danger of anticipating your own patent by what you file and disclose in registered designs. Did that answer your question there, Greg?
It did, yeah. Thank you, John. Well, it looks like we're wrapping up here. So, if you have any questions or things, please enter them quickly. One quick note, John works very closely as, of counsel with Schwegman, Lundberg, and Worcester, which provides an excellent avenue for anyone looking to, do design work from the U.S. We can help funnel that work over to John, or one of our, one of his colleagues, can help you with that work. So if you have such a need, feel free to, contact myself or John Gray. Our contact information should be available through our website readily. But again, John, thank you very much for your informative presentation today. It's much appreciated.
You're most welcome, Greg, and everyone. Thank you very much for your attention. And yes, there's a team of us at Schwegman in the UK ready to advise on design protection as everything else. Thank you.